Hello my dear friends and welcome to StudyIQ. I am Joy and today in this lecture we will be discussing about the issues with Cooperative Federalism in taxation. So we will see what are the issues related to Cooperative Federalism in taxation. First of all, let us understand what is the current affair. The Cooperative Federalism has been seeing some issues related to the implementation of GST. The goods and services tax implementation has brought about certain issues in the cooperative federalism of the country. So we will examine this issue in detail. We will see what is cooperative federalism. We will also discuss about the concerns related to cooperative federalism in India. Some of the famous judgments of the Supreme Court will be discussed, and also we will see what are the issues with cooperative federalism in taxation and what are the solutions. First of all, let us have an understanding about what is cooperative federalism. What is basically meant by a federalism? Federalism means division of powers between the government at the center and at the states. So we have a central government. We also have different governments at the state level. So the division of powers between the central government as well as the state governments is known as federalism. The powers among the center and the state is divided in the constitution in three lists, that is the center list, the state list and also the concurrent list. And in this three lists provided in the constitution, the powers has been divided among the center as well as the states. In the central list there are subjects where the center can take a decision. In the state list there are certain subjects on which the state government can take decisions, and on the concurrent list there are subjects where both the center as well as the states can make decisions. Now what is meant by cooperative federalism? Cooperative federalism is a concept of federalism in which the national government, the state government and also the local governments interact with each other cooperatively and collectively to solve common issues. So there is cooperation among these three tiers of the government, that is the central government, state government and the local governments. Cooperative federalism is also called quasi-federalism, and in quasi-federalism where a state, that is India, shares the powers between the union, that is the center and the states, but there is a tilt towards a strong center. Even though the powers are divided among the central government and the state governments, there is a tilt of power towards the central government. That means the union has more powers. For example, the concurrent list. On the concurrent list, both the center as well as the states can make decisions. But if both the center as well as state take a decision, the decision of the center will prevail over the state. So in such a way, there is more power to the union government or to the central government. We will learn about these features which make center or the union government more powerful in the polity lectures. Now we will understand what are the concerns regarding cooperative federalism in India. For that, let us understand two important Supreme Court judgments. The first one is S.R. Bommai versus Union of India 1994 case. Let us understand what was the case. So in the S.R. Bommai versus Union of India 1994 case, which dealt with the Article 356 of the Indian Constitution. So this case was the interpretation. The Supreme Court interpreted the Article 356 of the Constitution. So what is the Article 356 of Constitution talking about? It is the power of the President to proclaim a state emergency. So under the famous S.R. Bommai versus Union of India case, the Supreme Court verdicted that the power of the President to dismiss a state government is not absolute. So the President does not enjoy an absolute power to dismiss the state government under Article 356 of the Indian Constitution. And second judgment or the second important highlight of the judgment was that the presidential proclamation under Article 356 of the Indian Constitution is subject to judicial review. That means if the President in any case has declared state emergency under the 356 article of Indian Constitution, the state government can approach the judiciary in order to review the proclamation. So it is under the judicial review of the judicial system. And this judgment under S.R. Bommai versus Union of India 1994 case had a huge impact on the center-state relations. So, Article 356, that is the proclamation of state emergency by the President of India, this was one constitutional tool that was used by the center, because the President is appointed by the center, and as an agent of the center there are governors in the states, and the governors in the states will make recommendation to the President for a state emergency. So, the center through the governors can exercise its power to proclaim a state emergency. So, this provision was highly misused. So, with the SR Bommai versus Union of India case, this misuse was checked. So, this was a famous judgment with regard to center-state relations. And also regarding SR Bommai case, the Supreme Court had said that the floor of the house must be the place where the test of majority of the government should be conducted. We have seen this in case of Karnataka elections. The majority of the government should be proved in the floor of the house. Now coming to the second case, that is Government of National Capital Territory of Delhi versus Union of India. This was a latest case or a recent one. So here also a constitutional bench of the Supreme Court held that the Lieutenant Governor of Delhi had to act as per the aid and advice of the Council of Ministers of Delhi, and the exception was for matters regarding land, police and public order. So here we will see that the Lieutenant Governor is an agent of the center. So the center exercises its powers over the National Capital Territory of Delhi through the Lieutenant Governor. But in the government of NCT of Delhi versus Union of India, the Supreme Court made it clear that the LG or the Lieutenant Governor will have to act according to the aid and advice of the Council of Ministers. So, Council of Ministers are elected by the people, or we can say they are the representatives of the people. And the Supreme Court also made it clear that the Lieutenant Governor cannot interfere in each and every decision of the Delhi government or the Council of Ministers. So here also the Supreme Court was in favor of the NCT. So these two judgments made a huge impact on the center-state relations. But even though Supreme Court has come up with such judgments, the center continues to wield superior legislative powers. So from these examples, it is clear that the concept of cooperative federalism is doubtful in India. Now let us understand what are the issues with cooperative federalism in taxation. Let us take the case of GST. Under the Goods and Services Tax or the GST scenario, the state governments has foregone certain taxes. For example, octroi, entry tax, luxury tax, entertainment taxes, etc. So all these were the revenues of the state government, and the state governments have foregone all these taxes. But the power of the state government to levy taxes through panchayats and municipalities still prevails. So panchayats and municipalities can still collect such taxes. So this creates a confusion. So this is a situation where a certain transaction would be taxed under the GST, and under the local law, that is the law of the panchayat, and the municipalities would also tax the same transaction. So this is one confusion. Now the second issue is with regard to the sale of petrol, diesel, etc. Under the GST amendments to the Constitution, states have the power to levy tax on the sale of petrol, sale of diesel, etc. And the revenues from this will be going to the state budget. Now the GST Council, that is a decision making body under the GST system, has to recommend whether to include these items under the GST or not. So this is the second concern regarding the issue in taxation regarding cooperative federalism. Certain states are against this, certain states are for this. States are against this idea because if petrol and diesel will be included under GST, the states will be losing a large portion of its revenue. Now the third concern is regarding the tax sharing. This is according to the recommendations of the Finance Commission, and the Finance Commission recommendations would be accepted by the Parliament. So the states will not have a say in the recommendations of the Finance Commission. Parliament has the authority. So this is the third concern. Now let us understand what is the difficulty in GST structure. The state governments levies taxes which comes under the SGST or the state GST, and the state GST will come under the state's revenue. But the Article 269 1 of the Constitution, that is the GST Council as well as the Finance Commission has the powers to make recommendations in relation to sharing of taxes from interstate trade. In case of the GST Council, the states have a vote. So, states have a considerable voice in the decision of the GST Council. But now coming to Article 270 1A and 2 of the Constitution. So, under Article 271A and 2 of the Constitution, it provides that the taxes levied under the GST laws will be shared in the manner prescribed in Article 272. That means according to Finance Commission, not according to the GST Council. So, when it comes to the Finance Commission, the authority is the Parliament. But under the GST Council, what we have learned, the states have votes. That means states have a considerable say. But when it comes to the Finance Commission, Parliament has more authority. So, this will lead to anomaly between the roles and powers of the GST Council and the Finance Commission. The recommendations of the Finance Commission are placed before the Parliament and states will not have a role in the debate. Now, if a particular state or a group of states have certain objections regarding Finance Commission recommendations, what can they do? There is no provision for the state to challenge the report. But the only option that is left with the states is to approach the Supreme Court. So, such differences also needs to be rectified. You can find the PDF of this lecture on my Facebook page, and for any queries related to your UPSC preparations, you can get in touch with me on my Facebook page. I wish you all a very good day. Thank you.